Welcome to the weekend. I'm Jon Caldara, president of the Independence Institute and your devil's advocate. Well, get ready. You're going to learn more than you needed to or wanted to. Is it legal? Obamacare has another hit against it from a court in Florida. To talk about it from the Independence Institute, oh God, I'm so sorry, two lawyers. Dave Kopel, thank you for being here with us.
Thank you.
All right, and Rob Natelson, author of this book, The Original Constitution, available at Amazon.com. Thank you for being here.
Great to be here.
All right, so do I get a free copy?
Absolutely.
All right. Buy it.
Two free copies.
Two free copies. All right, first of all, let's bring it over to Dave. Give us the quick recap here. There's been several different rulings on Obamacare in the courts. The federal government hasn't been able to overturn it. The House did, but the Senate refused to. Where are we? Right now, we're 2-2.
Right. There have been 4 decisions by federal trial courts, federal district courts. One judge in Michigan, in a case brought by some private plaintiffs, like the Thomas More Law Center, said the law is constitutional. Another case in the Western District of Virginia, brought by Liberty University and some other plaintiffs. Liberty University was founded by Jerry Falwell, also upheld the law. A case in I believe the Eastern District of Virginia, Virginia versus Sebelius, brought by the Virginia Attorney General, said that the individual mandate is unconstitutional, but that it would not, that court only went as far as to say that. And in the case involving 26 states, plus the National Federation of Independent Businesses in Florida, on Monday, Judge Vinson in Florida ruled that the individual mandate is unconstitutional and that mandate can't be severed from the rest of the law. He agreed with what the U.S. Department of Justice has argued, that if you take the mandate out, the whole law falls apart.
Let me bring it over here. Explain that severability part. So we've got 3 judges, 2 of them said, fine, it's legal. One said, the mandate's not fine. This judge said, the whole thing, out, gone.
Yeah, this is a case where I think the administration was hoist by its own petard. In other words, it prepared a defense for the mandate, and then it prepared that defense so well that it wound up sabotaging its own case. Essentially, the Obama administration had taken the position that the individual mandate is necessary and proper, that's the constitutional language, necessary and proper to the operation of the whole law, and that without the necessary and proper mandate, the whole law would not be effective. So when the judge said the mandate's unconstitutional, he took them at their word and throughout the whole law. And in fact, there's good evidence that the mandate is central to the entire scheme.
And one thing that makes Judge Vinson's ruling correct is in the earlier drafts of the Obamacare law, there was a severability clause, which is often inserted by legislators to say, well, if one part of this big law is found unconstitutional, we, the legislature, intend that the rest of the law still be in effect. That was actually taken out. And things don't just fall out of the law by accident. It wasn't like on some this wasn't a 1932 law where it was lost on a slip of paper while they were compiling it. It was on a word processor. There was a decision made to delete it. And in essence, they gave a triple dog dare to the judiciary, saying, you wouldn't dare find that we're going to say, if you take the mandate out, it will pull the whole law down, and we don't think you'll have the nerve to do that.
All right, so I'm confused. Is the law in effect? Is the law not in effect? What's the call? Bring it over here. Well, if I own a tanning salon and I've got to be paying $10 as tax every time I tan somebody in a bed, do I have to continue to pay that tax? Does the Congress or the federal government still start doing all the prep work, or is it over?
Well, I think it's pretty clear if you're in a state where a court sits that has upheld the law, you better continue to pay the tax. Unfortunately, in Virginia, only the individual mandate was struck down, so you better continue to pay the tax in Virginia as well. On the other hand, for the other 26 states that brought this lawsuit in Florida, you can make an argument that those states are not bound by the tax because the entire law was struck down. It's a little bit uncertain in my mind because the court made the decision not to issue an injunction. The court issued only a declaratory judgment. If it had issued an injunction, it might have made clearer exactly what can be or cannot be done within the 26 states that brought that lawsuit.
If you're in the 26 states, will the insurance companies now say, you know what, we're going to continue doing our individual plans. We're not going to be part of the collection of the pools. It's over and done with in those 26 states.
Well, I think the insurance companies will likely continue doing what Obamacare says because, of course, they're the biggest beneficiaries of this. This is among other things, this is a gigantic corporate welfare program to force people to buy from this insurance oligopoly. You know, it's the funny thing that I say these sometimes dupes of Progress Now and then the other
MoveOn.org and all the rest.
Yeah, the left-wing noise machine are so full of rage against the health insurance companies, and yet you have this law that the insurance companies helped write, which says everybody has to buy their product, whether you like it or not. So they'll be the last to step out.
If there was a law that said everyone would have to buy a hamburger a day, McDonald's would put a lot of money into it.
Exactly, and even if McDonald's said, and you have to serve maybe some customers you would prefer not to serve, but everybody's going to have to buy your product, and in fact the federal government will subsidize people who can't afford your product to help them pay for it. Here I think is the key thing. As of now, where we have 4 different trial court decisions, the law is binding. At least each individual judge's decision is binding on the particular parties as between them. So for example, if Rob sues you and says, trial court issue an order saying John can't keep climbing in my window, turning on my television, and drinking all my beer to watch football games, and the court says that's right, John has to stop doing that, and I sue you in a separate case for the exact same issue, and the court says, no, John wins on that, he can come over and use your big screen anytime he wants. Well, what that means is maybe eventually the case will be heard by an appeals court and we'll get a consistent ruling, but it does mean as to Rob, you got to stop doing it, and as to me, I'm stuck with you coming on over.
Your simple point being, in those 26 states, you believe they are no longer bound by any provisions in Obamacare, any of them?
Yes, the plaintiffs in the Florida case, which includes Colorado and 25 other states, won their case. The National Federation of Independent Businesses was a plaintiff too. And I think at least those plaintiffs have clearly no legal obligation to comply with Obamacare.
You believe it would have been better if he put an injunction, say this thing is off the table until it's fully adjudicated? That's
right, because when a court issues an injunction, it defines precisely what the scope of the injunction is, and that wasn't done in this case. And it wasn't done, of course, because there is generally a rule in the federal courts is that the executive branch will be presumed to obey the law. They're not going to assume that the president is going to disobey the authority of the court.
But he is. He's going to disobey the order of the court from this Florida district court. He's going to continue having the executive branch put all the machinery together for Obamacare, is he not?
Well, that's why I think the court should have issued an injunction. I think the court was being naive about that. The Obama administration sees it very important to lock this law in, to institutionalize it, to get people to rely upon it. So that it can't be changed in the future.
There were a couple of gems in this 78-page ruling. Give me a couple of them. I was thrilled.
Well, a great one was where the court said it's not to be presumed that a country that was founded partly on the refusal to obey a mandate to pay a tax on tea would empower a government to force you to buy tea. That was one of the comments that the court made. The example you gave a minute ago, John, about a law forcing everybody to buy hamburgers, that's not a wild hypothetical, because a number of progressive or liberal legal scholars have been asked, if people can be forced to buy insurance, can't they also be forced to eat broccoli, for example? And their general answer is yes, unless you can point to some provision in the Constitution that protects the right to consume food or the food of your choice. The federal government can force you to buy any product. And that's one of the reasons why Judge Vincent reached the decision he did, simply because there are no effective or very few effective limits to the federal government if this law survives.
How powerful is this decision? You've read it as well. Is this the one that's going to bubble up to the Supreme Court? Will it be one of the other 3 cases? What goes on next? Talk to me a little bit about the mechanics.
When you have 26, we've never in the history of this country had a majority of the states suing to have a law declared unconstitutional.
Never, not once.
Never, ever, ever. So that really says a lot. in itself, and when we have the 26 states in the Colorado and Florida case, and plus Virginia has its own case, and Oklahoma has announced it's going to start its own, so there's 28. I think it's very likely that ultimately the Supreme Court will take perhaps the Virginia case and the multi-state Florida case and consolidate them. This is a court that for the last 20 years has been very strongly concerned with protecting the sovereignty of the states, and done it on a whole wide variety of legal fields. And
they can combine cases. Why don't they just take all the cases? Does that mean all the lawyers, all the plaintiffs' lawyers have to all work together whether they want to or not?
Oh, that's sort of up to how the Supreme Court wants to structure it, and who they make the particular parties. They might, for example, say, if they take the Virginia case plus the Florida multi-state case, they could say, and Virginia will get half the oral argument time, and Florida will get half the oral argument time.
But talk to me a little bit about the mechanics. We have this federal judge. Yeah. Doesn't it then go up to a court of appeals, and then it goes up to the Supreme Court? I mean, how long is this going to take, and why isn't it being fast-tracked?
Well, in the normal, the Attorney General of Virginia, Ken Cuccinelli, has just filed a request with the Supreme Court for an expedited review. The Supreme Court has the option to do that in cases of extraordinary importance, which I think you can say that this is. And certainly the states, each of them are having to spend tens of millions of dollars to do the, if the law still is legally mandatory, to do the preparation work as various parts of the law come into effect. And of course it's enormously significant nationwide in every possible respect. So there's a good argument why the Supreme Court should take things on the fast track. Sometimes the court likes to say, well, we'll let some Court of Appeals decisions come around. Maybe those will have some good ideas that we can use in our opinions, or we can see the diversity of how people look at it. I think this is a well-developed legal issue that the court could, if it chooses, take right away. But even if it goes through the normal Circuit Court of Appeals process, I think we could be easily looking at the Supreme Court taking it and hearing oral arguments in 2012.
All right, let's get into what you guys love, the wonkery of this. Now, you spent a whole book on the original Constitution. Mm-hmm. Under what power does the federal government say they have the authority to mandate me to buy any private product? How are they arguing this? And then let's go through the different arguments.
Article 1, Section 8, Clause 3 of the Constitution gives Congress the power to regulate commerce among the several states. And so the Obama administration argues that commerce includes insurance, and there is a 1944 Supreme Court decision that says that, and that because they have the power to regulate insurance, they also have the power to impose the mandates necessary to this wider scheme of insurance regulation. Under the laws the Supreme Court has developed it, this actually is a fairly close case. It's one of the reasons why the courts have split 2-2. Under the original Constitution, under the Constitution as the founders intended it to be read, it's not even a close case. Almost all fields of insurance are a matter for state, not for federal regulation.
So a state usually has an insurance commissioner. That insurance commissioner enforces the laws of that state. This is why Massachusetts, for instance, can have their own little mini version of Obamacare and force people to buy it. The states have that power. You're saying that the feds don't have that because this is not a cross-state issue. Is that what you're saying?
For well over 150 years, it was understood that only the states could regulate insurance. That was changed in 1944 in a very weak decision by the United States Supreme Court. Congress then passed legislation essentially saying we're not going to take advantage of the Supreme Court's decision. The states will continue to regulate insurance. This particular bill, John, represents the first really, truly huge intrusion by the federal government into the insurance market, as well, of course, in several other areas.
Talk to me a little bit about the Commerce Clause, because it seems as though the Commerce Clause has been exploded in a way that now almost everything is empowered. Now, the Constitution says Congress can only do a certain number of things. They can print money, they can put up post offices, they can have trademarks and patents, they can raise a military, they can do those things, and anything else is left to the states. So if it's not in there, they can't do it. But under the Commerce Clause, saying we can regulate commerce between the states, That seems to be everything. And there's been some terrible decisions on that.
Well, exactly right. And the Commerce Clause has been perverted to grant, as if Congress had the power to do something which the people of the United States deliberately withheld from Congress when they created the Constitution, which is a general, what's called the police power, sort of a general power to regulate everything for health, safety, welfare, and morals. That's a power that inherently resides in the states. It was never granted to Congress, and as you say, the Congress was instead granted certain powers to do some things very well, but not to go and do everything.
We didn't want all the states to print their own money. We didn't want all the states to raise their own armies. We didn't want all the states to have treaties with foreign countries, except these are federal issues.
Right. And so Chief Justice John Marshall, the greatest Chief Justice of all time, he was basically the first third of the 1800s, and he had written a biography of George Washington, knew Washington well. He was one of the founders dating back to the Revolutionary times, was very familiar with the original meaning of the Constitution. And he was also a very strong nationalist. So in the Marshall Court's decisions, when there are close cases about the meaning of federal power, he got usually a unanimous Supreme Court to read federal power very broadly. And he's one of the reasons we have a strong and effective national government, which is one of the things the Constitution was made to create. And he also understood that strong and effective does not mean infinite. So the big case, even today, for a strong interstate commerce power within actually covering commerce itself and not other things, is called Gibbons versus Ogden. And in that case, he defined commerce in a very sweeping and extensive way. And in that very same case, he said, you know, let me tell you some of the things that are not part of interstate commerce that are subject to congressional control. Health laws of every description.
Now, when was this decision made?
1824.
So in 1824, there was a Supreme Court decision basically saying that the federal government cannot get involved in health care laws.
That's correct, John. And this
wait. Then why do they do it? Why? I mean, we've got federal health care laws out the wazoo.
This was the understanding right up until the 1930s. In the 1930s and early 40s, we had a terrible economic depression. Congress wanted to essentially regulate the entire economy. Franklin Roosevelt was able to appoint a majority and ultimately all the justices on the Supreme Court, and the justices changed the law. They changed the law in sweeping ways, and one of the ways in which they changed the law was essentially to allow the federal government to regulate the entire economy, clearly in contravention to what the founders had intended. And of course, we're still seeing the pernicious results of that today.
All right, let's bring it to today. You know, sooner or later, this is going to bubble up to the Supreme Court, and if nobody dies of a heart attack in between then and now on the bench, I think there's a good chance this thing is going to be declared unconstitutional. But I have some concerns. First, let me talk about Scalia. Didn't Scalia weigh in on a states' rights issue on medical marijuana that really didn't go our way?
That's right. In 2005, he concurred with a majority opinion that allowed the federal government to regulate medical marijuana, even though the personal consumption traditionally wouldn't be understood as an economic activity. Right. However, it was still an activity, and that's the difference. The line drawn by Judge Vincent in this case is it's one thing to use the commerce power to regulate economic activity. It's another thing to use the power to regulate people who are not active, who are doing nothing, and ordering them to do something.
I want to get to that, but that law on medical marijuana, basically Scalia agreed with the idea that if one state has people using medical marijuana, it's going to change the supply and demand of medical marijuana in other states.
That's
so
right.
Therefore,
that's right.
So if I buy too many hamburgers in this state, it's going to be fewer in another state that might be available and affect that price there. So under that law, can't they regulate everything?
There's only one justice on the court who really doesn't think they could regulate almost everything, and that's Justice Thomas. However, Justice Scalia is willing to be a little bit more restrained about it than some of the other justices. I think there are 4 justices on the court who basically give a blank check to the federal government for virtually any regulation it wants to pass, unless it violates some specific provision of, say, the Bill of Rights as they see it. But generally, you only have one justice on the court, Justice Thomas, who consistently takes the view that the federal government is not only a government of limited powers, but of fairly sharply limited powers.
Bring it over here. Do those decisions bode poorly for us?
Well, I wish they'd gone the other way, but I would say not. Here's the Raich versus Gonzalez is a woman who is, the case Rob talked about, a woman who's growing medical marijuana pursuant to California law for her own consumption. It's really just a sort of micro application of the case Wickard versus Filburn, which was well established and the court has shown no intention to overturn, which is a case that says under the New Deal, the federal government basically wants to set up a cartel in wheat and control the interstate market in wheat, and that pursuant to their desire to control the interstate market in wheat, they can also make these cartel rule applies to a farmer who grows wheat on his own land only for consumption by himself and his horses and so on. So, but that's still
the thought being, here's a farmer growing his own wheat he's going to use for himself and his family, not sell to anybody. But the federal court said, well, but that's wheat that maybe you would have bought in the marketplace if you didn't grow, and therefore it has an effect in the supply and demand of wheat. Therefore, we can tell you that you can't grow wheat.
Exactly, and Raich versus Gonzalez is essentially that rule applied to marijuana. The difference, though, is nobody said, here's why this case goes, the Obamacare goes far beyond even where the Supreme Court has so expansively gone. Nobody said that you could force Mr. Wickard to eat wheat, that we're going to support increase the demand for wheat by forcing people to buy wheat, and or we can force people to buy any particular product just as a matter of economic regulation. And here's the key thing. In the Senate Judiciary, people said, oh, well, that's just a hypothetical scenario, and, well, health insurance is somehow some of this magically different market, and making people buy health insurance products of a type they don't want doesn't have any implications for making people buy other products. Not true. Before the Senate Judiciary Committee this week, they had, for the first time, a hearing on the constitutionality of Obamacare. Would have been better if they'd had that hearing before enacting it, but hey, better late than never, and good for them. And one of the defenders of Obamacare, Harvard professor Charles Fry, very eminent, distinguished guy, said, yes, in fact, his interpretation of the Constitution, which means you can force people to buy health insurance they don't want, likewise means you can force people to buy broccoli if they don't want it. If you think there's not, he didn't say, in his view, you can't force them to eat it, but you can force them to buy it. In the same sense, you can force people to buy health insurance, which they don't want and may never use because maybe they're into chiropractic or aromatherapy or holistic healing or whatever else. You can force people to buy products you don't want. Likewise, Erwin Chemerinsky, California law professor, author of probably the most widely used constitutional law casebook in the country, very influential progressive law professor, also agrees that the same principle that upholds Obamacare means that, for example, the government could force you to buy a General Motors car to help support the economy. That was cited in Judge Vinson's decision. I don't think you have 5 justices on the Supreme Court who are willing to take this radical step of going further. It's one thing to regulate what you do. Right. It's another thing to force you to do something.
Let me see if I understand. You said this about activity. So even if they have the ability under the Commerce Clause to regulate activity, now they are going to force activity. This will be the first time that they're regulating non-activity and say, you're going to get active. And at this point, as you know, the little economist in me goes nuts, because if you can force somebody to buy something, there is no more free market. The
argument that because you can regulate activity, you can also regulate inactivities is just absurd. I mean, and here's a simple hypothetical. The Constitution gives Congress the power to define and punish piracy on the high seas. By the same argument, the federal government could punish Jon Caldara for not being a pirate. I mean, when you look at it, you realize
that's not an issue.
Yeah, right. When you look at it from that standpoint, you realize just how absurd the argument is, and that what is really going on is an attempt to change the Constitution through construction, basically to turn us into a situation where the federal government is all powerful. That appears to be the goal.
I have a couple minutes left. What if they're not saying we're empowered to do this through the Commerce Clause, but there's other powers that the federal Congress has? They have the power to lay taxes, and they're already collecting taxes from tanning salons, and in a few years they'll be collecting taxes from all of us. Tell me, why don't they just say, or have they said, No, this isn't about regulating commerce. This is all about taxation, and we're empowered to do so.
Well, of course, that's exactly what they did say. After the law was passed for litigation purposes, the Obama administration said, you know, this mandate that we're imposing on people is really just a tax. None of the courts have bought that.
None? None of the four decisions?
None of the courts. Even the courts that have ruled for the Obama administration on the Commerce Clause issue have held that this is not a tax.
Or some have been agnostic. Some have said we don't have to decide this.
That argument is really not flying. The exaction was put on people to force them to buy insurance. It wasn't really put on people to raise any revenue.
So the idea that this is going to be they're empowered to do it because it's a tax. You don't think that's going to fly?
Well, the tax power is very, very broad. And so, for example, the tax on tanning salons, if it were enacted in if we're not on this Titanic of a bill, could certainly be passed on its own and would unquestionably be constitutional. But the fact is, it's not a tax according to the bill itself. There were earlier drafts of the bill that characterized it as a tax. Those were changed, and the tax language was taken out and was called a penalty instead. President Obama, talking to George Stephanopoulos, on the ABC Sunday morning show, was asked about this specifically, and he said, no, George, it's not a tax. And Stephanopoulos kept pressing him pretty hard, and the president insisted. So courts are not, when Congress says something is not a tax, courts are not going to presume that Congress was actually lying and really meant that it was a tax and it meant to use its taxing power. And besides that, it doesn't fit in kind of any constitutional tax.
Let's wrap this up. Years from now, a couple years from now, or whenever the Supreme Court rules, does this stand? Will the Supreme Court overturn it?
If I were a betting man, I think it's a loser in the Supreme Court. I think it's going to be close, but I think it's going to be a loser.
And you?
5-4 opinion by Chief Justice Roberts.
And Roberts
says that this is unprecedented and unconstitutional.
You heard it here first. Lay your wagers down. I'm Jon Caldara. Learn more about the Independence Institute at independenceinstitute.org. Tell a friend. We'll see you next week.